Hi, David Henson with Henson Fuerst Attorneys again. In other videos, I've talked about liens and subrogation interests, which all involve someone else trying to get their hands on your settlement proceeds after your case is resolved. If you missed those videos, then you might want to go back and watch them as well. Liens, subrogation interests, and reimbursement rights are all related. The common denominator is your money. Today, I want to talk about those government agencies that also want to get their hands on some or all of your settlement proceeds. This video is for anyone with Medicaid or Medicare or any other government health insurance program. If you don't take advantage of any of those benefits, then feel free to click stop and go to one of our other educational videos. If you have Medicare or Medicaid, however, you need to know that they have a statutory right, which means a clear legal right to get repaid out of your settlement for any amount of money they paid on your behalf. Now, for the complicated part, each of these agencies gets paid back in different ways with different sets of rules. Here's some basic information though. For Medicare, since it's a federal program, Medicare gets paid first out of the settlement. As a general rule, Medicare must reduce their lien by 1/3 for attorney's fees, but otherwise they have a right to full repayment. If you have a very large settlement and only a small Medicare lien, then this will be easy to resolve. However, if you have a small settlement but a very large Medicare lien, then you can have a real problem on your hands. Medicare can gobble up all of your settlement proceeds before anything else is paid to anyone. Unfortunately, we run into this situation regularly. In an attempt to reduce the amount repaid to Medicare, quite often we have to resort to certain appeals for a waiver or reduction of the lien. Now, Medicaid in North Carolina has a different set of rules. They get in line behind Medicare in order of priority. If you have Medicaid, then as a general rule, they get treated the same as a valid lien holder. This means that North Carolina Medicaid, together with the other valid legal lien holders in North Carolina, cannot get more than approximately 1/3 of the settlement proceeds, no matter what amount they paid in your case. Some of you may have both Medicare and North Carolina Medicaid, in which case the situation can get exponentially more complicated depending on the amounts paid by these agencies, the amounts of settlement of your case, and the amount of outstanding medical bills. Unless there's plenty of money from the settlement to pay back all of these agencies, then I strongly encourage you to talk with legal counsel to get some assistance. You absolutely want to make sure that you pay these agencies back correctly. One, because they can stop future benefits if you don't, and two, since they're the government, they have the ability to come after you civilly or even criminally under the law if you stiff them. We focused today on the two major government health insurance plans of Medicare and Medicaid. If you have one of the other government health insurance plans, such as Federal Employees Health Insurance Plan, TRICARE, Champus, or VA benefits, then shoot me an email at dhenson@lawmed.com and let me know to do a future video on one of those agencies if you'd like more information. No matter the kind of insurance, if your case involves any government health insurance, Medicare, Medicaid, TRICARE, Champus, or VA benefits, then you need to proceed carefully with the settlement and resolution of your case. You should know in advance that these agencies will be standing with their hands out when your case is resolved. It's critically important that you and your lawyer follow the laws and, when possible, attempt to reduce or minimize the amounts that must be paid back. This is David Henson with Henson Fuerst Attorneys. If you have additional questions, please go to our website at lawmed.com. If you have questions, Henson Fuerst has answers.